The mood lighting in today, which I really appreciate.
About the lighting.
Okay, let's go ahead and call us to order. I want to recognize Counselor Jacob for her thoughts and for leading us in the Pledge of Allegiance, please.
Thank you, Governor.
Reflections, I should say.
Yeah, I think today I want to reflect upon the pledge we are about to take and put out a hope out into the world that those who are fighting to preserve our democracy right now get all that they need to be effective and succeed in that. So I just want to take a moment. I pledge allegiance to the flag of the United States of America,
To the republic which stands one nation under God, indivisible, liberty and justice for all.
All right. Everyone has got a busy day ahead of us. If I could recognize Counselor Kennedy, the birthday boy, for a motion to record advice and consent for the financial warrant.
Don't move, Governor.
Is there a second?
Second.
Seconded by Counselor Ziegler. All in favor? Any opposed? The ayes have it. I'd like to recognize Counselor DiPaolo for a motion to record advice and consent for the pending list of notaries public and justices of the peace. Moved. Is there a second? Seconded by Counselor Jacobs. All those in favor? Any opposed? The ayes have it. And I know we have 4 new nominations. Laurel Baracco to the position of Associate Justice of the Probate and Family Court. Counselor DiPaolo, my understanding is you're going to hold a hearing on February 26th at 10:30 a.m. All right. And then Bethany Brown to the position of Associate Justice in the Probate and Family Court as well. Counselor Ferreira, that one's yours. I've got February 26th at 1:30.
Yes, Governor.
All right, that's accurate. Then we've got Evelyn Patsos, the position of Associate Justice of Probate and Family Court again, and Counselor Kennedy. That hearing will be held today. Is that accurate?
It's 7 minutes.
As soon as we get out of here. All right, perfect. And then Brian Salisbury for the position of Associate Justice of the Probate and Family Court. Counselor Silva, you're going to hold the hearing on the 26th at 2:30. Is that right?
Yes.
Okay, I think that's all we have. So I'd entertain a motion to adjourn.
Don't moved.
This is made by Counselor Ferrero, seconded by Counselor Ziegler. All those in favor? Opposed? The ayes have it. We stand adjourned.
be chairing this meeting, and I am going to read a letter from the governor dated January 29, 2025 to the Executive Council. Dear Council, I'm pleased to nominate Evelyn Patsos to the position of Associate Justice of the Probate and Family Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy. I'm going to introduce the councilors. We have Councilor Iannella, we have Councilor Ziegler, we have Councilor DiPaolo who stepped out, and be right back, Councilor Jacob, Councilor Ferrara, Councilor Civil, and Councilor Dolan. And my name's Terry Kennedy. All right, we're going to start with having you introduce everybody you brought here today. That should take up the rest of the afternoon, and we can call it a day.
I am going to hold off on introducing family members. They're until I get to my remarks, but I would like to introduce colleagues that are here with me in support. And I would start with the Honorable John Casey, Chief Justice of the Probate and Family Court.
He's always here. We're used to him.
And then Dominic DiCenzo, who's our Deputy Court Administrator. Also here today is the Honorable Lisa Roberts, retired justice from the Plymouth Division of the Probate and Family Court. And also Judge Edward Donnelly, who is the retired justice of, first justice of the Middlesex Probate and Family Court. And then my witnesses are the Honorable Elaine Moriarty, retired justice of, technically, are you something? She's with the fiduciary litigation session at this point. We dragged her back from retirement of all of one day. And then also Notice McConaughey of Hemingway and Barnes and Tom Jalkett of Nutter.
Okay, very good. So we're going to start out by calling your first witness, the Honorable Moriarty, retired Justice of the Probate and Family Court. Welcome back to the Governor's Council.
Thank you. It's a familiar place. May I sit or should I stand?
You can sit. You can sit.
Chairman Kennedy and members of the council, I want to thank you for the opportunity to be here this afternoon and speak on behalf of Evelyn as a nominee for the Probate and Family Court. Over 17 years, I have known and worked with her at the court. I believe she has one of the most extensive and impressive blends of probate and family law expertise that I've observed in my many years on the bench. Traditionally, as you know, the probate court work has been weighted toward domestic relations matters, such as divorce, custody, domestic violence. These high volume cases continue at present to be the dominant portion of the court's work, and they require prompt and ongoing attention. However, with the enactment of the Massachusetts Uniform Probate Code and the Massachusetts Uniform Trust Code, there's been a growing emphasis on probate matters, particularly in the mental health, guardianship, estate litigation areas. It's my belief this is going to increase further as the population ages, and we'll see more litigation in these areas. For example, litigation involving the scope and validity of healthcare proxies, durable powers of attorney will become more frequent as greater use of these legal vehicles in estate plans is seen. And I believe Attorney Patsos has the needed skills and interest in this area, and much desired and needed expertise to this aspect of probate work. It was my privilege to work closely with her when I co-chaired the Massachusetts Uniform Probate Code Implementation Committee. And this committee was established by then Chief Justice Paula Carey to put into practice the extensive changes in probate law which the legislature had enacted, and it had to be completed within a very short time. Attorney Patsos started out as a volunteer on our committee and quickly became a key person. He worked tirelessly to analyze major statutory changes been enacted, to undertake necessary research, develop and lead participation in requisite educational training programs, and that's for judges, staff, as well as attorneys. He also oversaw the development of the court's probate practice manual, which is really our guide and which has been such an assistance to judges and attorneys. And this work was a massive undertaking. The changes in the law were seismic. She was instrumental in helping to develop the fiduciary litigation session. This is a special session established by the Chief Justice to expedite trials on complex probate litigation. I now sit along with Judge Donnelly as a recall judge. It's been very well received. Throughout, she has unstintingly shared her knowledge and expertise with the bar and participated in their educational programs. She's reached out to assist other entities such as banks and nursing homes whose practices are impacted by these changes in the probate code. In stressing her probate experience, and I personally believe the court does need more judges with this background, I do not understate her domestic relations expertise. She has worked in both private practice and the public sector and understands the demands on practitioners in both sectors. She herself started out working at Neighborhood Legal Services and Senior Partners for Justice, providing legal services for low-income indigents who very much need talented legal representation in a system that they sometimes feel can be overwhelming. She also worked at the law litigation firm of Gallant and Irvin, representing clients in all phases of domestic relations litigation. Law facilitator, the Worcester Probate Court. Finally, she unquestionably has the temperament to be a good probate judge. And in my view, temperament is as important a quality as legal skill. And that's particularly true, I think, in probate. When litigants come before us in the most stressful times in their lives, when we are dealing with the most personal aspects of their lives, they need to feel that they have been heard. Any litigant appearing before those would be a knowledgeable, conscientious, and respectful jurist, hearing their most sensitive issues to provide a fair and just result. It's my hope that you would all act favorably in confirming her. She would be a credit to the governor and to the council as an appointment. Thank you.
Thank you, Judge. Does anybody have any questions of the judge?
Thank you.
Thank you very much, and congratulations on your retirement.
Thank you.
I'm enjoying it. Okay, next we're gonna call Attorney Thomas Jelcut. I said that correctly. A partner at Nutter, McLennan and Fish.
Thank you. Chairman Kennedy, members of the council, I'm going to be brief. I'm not a litigator, so I can't really comment on Evelyn's skills in that regard. But I can tell you that when the MUPC was enacted in 2009, it was such a revolutionary piece of legislation that snuck up on those of us who were in the bar. I had already been practicing for 33 years when it was enacted. And I was my experience in expertise had been devalued overnight, I felt. And I think most of the practitioners, whether they be solo practitioners or people who big firms, felt the same way, because the language, the concepts were so different from the 200 years of experience that we had in probate law in Massachusetts. Fortunately, we were given a couple of years to get used to these concepts in the probate of wills and estates before the law became effective on March 31, 2012. Evelyn, along with former Judge Nisi, developed education programs, and we went all over the Commonwealth, lecturing to, talking to lawyers, bar associations, trade groups, court personnel, judges, trying to acquaint them with the law. This was something so revolutionary that first we had to talk about what the law said. And as Judge Moriarty said, that's one thing, but then how to implement this new law was something altogether different. So Attorney Patsos, Judge Moriarty, Judge Roberts, and one or two others, we spent every week for an hour or an hour and a half developing procedures to recommend for the use with this new law. Then eventually involved the drafting of a procedural guide. And what Evelyn's Attorney Patsos's real genius is that she was able to make that language not only approachable by lawyers, but also for the laypersons who frequent the court. You want to know how to file a petition for probate. There are detailed instructions, step-by-step processes that are laid out in this procedural guide, which is on the probate court website. Very useful indeed for everyone. In addition, in 2016, I asked Attorney Patsos to be my co-editor of the Massachusetts Probate Manual, which is written for lawyers, but it is really one of the publications from Massachusetts Continuing Legal Education that is in great demand. And every year, we have programs to go over these changes, these procedures that are in the MUPC. We've probably done 30 programs together since 2009 when the MUPC, I keep saying MUTC, but that came in 2012 too, and that has its own problems. But Evelyn, Attorney Patsos, co-chaired almost all of these programs. And I think everyone in attendance at them would say that she did so in a way that was accessible, filled with humor. She was able to get across the salient points without hectoring people. She has been an incredible resource in the chief's office for all of the members of the bar. People reach out when they have questions, not all of them good questions, but when they have questions on procedures, or they run into obstacles in the various divisions of the probate court, they can call Evelyn or Attorney Patsos, and she then will help them, guide them through what they need to do in order to accomplish their goal. So I can't stress enough. Judge Moriarty talked about her temperament. To be able to suffer the fools of the bar as well as she has over the past 15 years is remarkable, because she never loses patience, at least not outwardly anyway, and has helped all of us in numerous ways, because it is something now where I feel like I know what I'm doing with the MUPC, and that's mostly attributable to Attorney Patsos. So that concludes my remarks.
Thank you very much. Does anybody have any questions? Thank you very much. We appreciate your testimony. And now we have your final witness, Attorney Edward Notice McConaty, partner at Hemingway and Bonds. Welcome.
Thank you, Chairman Kennedy, and it's remarkable that you were able to pronounce my name. It's very rare.
I practice all week.
Thank you very much, and the fellow other counselors too. I appreciate the opportunity. My name is Ned Notice McConaty, and I'm very pleased to be here to address you regarding the nomination of Attorney Patsos for a position on the probate and family court bench. Attorney Patsos checks all the boxes when it comes to consideration for a judge of the probate and family court. I've spent 45 years practicing law here in Boston, much of that time in the probate and family court, helping families through some really hard times, oftentimes heated litigation. There is no one over the course of that time that I was more confident would make an excellent probate and family court judge as I am about Attorney Patsos. First, Attorney Patsos is diligent. She's a diligent, hardworking attorney. I first got to know her when we both worked on changes to the court rules that Attorney Jalkut was just talking about. In most cases, Attorney Patsos was chairing those meetings. She was chairing those presentations. She knows how to sit in front of a room and graciously listen and move things along. And I can't believe, I never have been able to believe the amount of time and effort that she put in a very patient way. When she was first doing this work, she was an assistant registrar in the Worcester County Probate and Family Court, and this was all extra work, all nights and weekends, in addition to her usual work. She never seemed anxious to leave. She had such patience and persistence. She just is a very dedicated and a patient, public servant, and the people of Massachusetts are very lucky to have her. I would even go so far as to say she enjoyed the challenge of the hard work, often long after expected quitting time. She has consistently over the years dedicated her evenings to professional meetings, meetings of the bar associations, and to the probate family inn of court, where she's accessible to people, reach relationships, which then allow the attorneys to call her when they have a problem in the probate family court that they're having a hard time resolving. Go over to the probate family court, I submit my pleading and my petition, and someone at the desk tells me, sorry, you didn't check this box, or you didn't use the right color ink, and I know they're wrong. I can go back and give Evelyn a call and say, who do I talk to? How do I deal with this? She makes the system work, and it eliminates a lot of the frustration. During her 10 years at the administrative office of the probate family court, and as an active assistant register, she established herself as the go-to resource at the court on probate and many other issues. She's always been available to help and serves the people of the Commonwealth in the best possible way. She quickly and thoroughly grasps new and complicated concepts and sees through the details that slow others down. Probate and family court has jurisdiction over very complex, different areas. She spent her first years representing clients in divorce cases, which represents a large part of what the probate and family court does. That's critical expertise. She has it. Not only did she represent clients in divorce cases, and as an assistant register, she saw those cases tried. She saw how good judges handle those cases, and the patience and good humor with which she would do that work would be a wonderful gift for the probate and family court. She also has extensive experience in mental health and guardianship issues, having served as chair of the Supreme Judicial Court Working Group on Substance Abuse and Mental Health, and advisor, mental health advisor. She was also advisor to the Public Guardianship Pilot Program. Serves on the board of directors of the Mental Health Legal Advisors Committee, and received he's a recognized star when it comes to tough guardianship issues. He has deep expertise in guardianship, trust, and elder law issues. But of all the issues that come before the probate and family court, issues relating to wills and trusts and administration of estates can be especially mean and complicated. Many practitioners, frankly, most judges in the probate and family court, have little experience or substantive knowledge about the area. So much so that special sessions of the court, tertiary litigation session, have been established, overseen by a few judges, two of whom are here in the courtroom with us today, recognizing Evelyn's special expertise in that area. She has exceptional grasp of the law and the practice in the probate and estate matters. This expertise is in short supply other places on the bench. While she has a deep knowledge and experience in the different kinds of matters in the probate and family court, her expertise in probate and estate matters will be a unique contribution to the probate and family court bench. These are the very types of cases I've been handling for many years, myself and others at Hemingway and Barnes, over a century now. It's so important to walk in and have a judge who understands it. It's really hard to learn it if you haven't been absolutely immersed in that work over the years. And Attorney Patsos has really been immersed in that work and understands it. Several prior witnesses have talked about Attorney Patsos' judicial demeanor. I'm sure it's going to be terrific. He's shown a willingness to listen. Very important for a judge, particularly a judge overseeing probate and family disputes. But she knows how to move cases along. She's not going to listen and listen and listen without making a decision, or listen longer than she needs to. The parties are going to leave. They're going to know they've had an opportunity to be heard. Then they're going to get a decision, and it's going to be a good decision. In closing, I want to leave a simple message. I have practiced law for 45 years at Hemingway and Barnes. My practice is at the heart of the firm is in the probate and family court. The quality of probate and family court judges is critical to the administration of justice for families in Massachusetts. In confirming Attorney Patsos, you will be doing Massachusetts families a great service. Unless there are any questions.
It sounds like she's been an incredible asset to the probate court as an assistant registrar. It's gonna be a great loss.
I want
She's
you,
gonna be too big a loss. We can arrange for her to stay there.
that's a big issue. I once introduced Attorney Patsos when she was getting an award from the fiduciary litigation in of court. And I described her as the Siri of the probate family court. Because you could pick up the phone and ask any question and you would get the right answer. I mean, she's really remarkable in the depth of her knowledge.
Does anybody have any questions? Thank you very much for your testimony. Now, that'll close the portion of the hearing with respect to those in favor of the nominee. We're gonna open it up for those in opposition. Joe, there's about 30 people in the hall. I don't know if that's why we're here. Could you check? Okay. Hearing none, we'll close that portion and the floor is yours.
Good afternoon, members of the Governor's Council. Thank you for all of your time today. I appreciate you considering my nomination and for meeting with me this past week. I deeply appreciate your role in this important process and all that you do on behalf of your constituents. I would also like to thank Governor Haley and Governor Driscoll for nominating me to the position of Associate Justice of the Probate and Family Court. There are no words to tell them what is in my heart. I can simply say that if I am confirmed, I will try in every way to justify their faith in me and perform this role with fairness and compassion. Thank you to the members of the Judicial Nominating Commission and to the Governor's legal staff, Chief Legal Counsel Paige Scott-Reed, Deputy Legal Counsel Dara Kesselheim, Valerie McCarthy, and her team. Everyone has been so kind to me. I'd like to thank my colleagues, friends, and family who are watching me today on YouTube. I would not be here today if it were not for the love and support of my two children. I'd like to tell you a little bit about them. My oldest, Elena, graduated from the Commonwealth Honors College at UMass Amherst with a degree in both history and economics. She is now studying to be a certified financial planner. At the same time, she's raising two beautiful children, my beloved Michael and Francesca. She does this with her wonderful husband, Greg, my favorite son-in-law. My youngest, Olivia, is in her third year of residency at Columbia in New York. After 9 years of school and moving her in and out of about at least 4 or 5 different states, she will finally be returning to Massachusetts in June. She's taking a position as a primary care physician with Boston Medical Center's Neighborhood Health in East Boston. And we're all thrilled. Elena and Olivia, your dad and I are so proud of you. You've grown up to be kind, loving, and well-adjusted women. You are the beautiful result of healthy co-parenting by parents that are divorced. Our motivation has always been you. So let me tell you a little bit about me. I am the youngest child of what I refer to as the original 3. My parents were divorced when I was very young. My mother and grandmother raised me and my sisters in my grandparents' 2-family home in Medford. My mother later married a great man who became known as Dad. Together they had 3 children, and this made me now the middle child of 6 in this loving, blended, working class family. I finished growing up in Burlington and graduated from the Burlington Public School System. I didn't know it at the time, but with 6 kids, my parents lived paycheck to paycheck. My mother was a stay-at-home mom, and my dad never once called in sick in his entire life to make sure that we had a roof over our heads, family dinners, and sometimes a trip to our favorite restaurant, the Calhoun. But there wasn't any extra. My parents are now both deceased, but like every parent, they did the best they could with what they had. And they, along with my grandmother, instilled in me the value of hard work and the importance of family. Counselors, you have received many documents about me. This body of material, I know, has been examined by you with care. But my journey has not been one without its challenges and struggles. It certainly hasn't been, some would say, the typical path to the bank. And I'm okay with that. The judiciary should be as diverse as the people that come before it. I was the first person in my family to graduate with a college education. Because of my family's financial circumstances, I worked full-time during the day, attended school at night, on the weekends, and throughout the summer. When all was said and done, it took me close to 10 years to get my undergraduate degree in psychology. And there are so many people that I could thank along the way, from teachers to my former in-laws. By the time I had decided to go to law school, I was in the middle of my own divorce with a 7 and a 10-year-old by my side. So it was a little bit different than the usual path. Most students in law school are not studying alongside their own children, and certainly probably not doing science and other projects with them and trying to read cases at the same time. I held things together the best that I could to make sure my daughters had a good relationship with their father. Law school was challenging and exhilarating, but it was my own divorce experience in the New Hampshire court system that was transformative. The judge handled our case with remarkable fairness and empathy. He listened patiently to both sides, asked thoughtful questions, and kept the case on track. His guidance allowed us to prioritize our children's well-being and find ways to give and take. Although we didn't always agree on everything, we never lost sight that we were both on the same parenting team. We have helped our children learn how to face life's challenges with honesty and maturity. They understand the importance of coping without hatred or blame. The judge's ability to balance compassion with justice left a lasting impression on me. I later clerked with this judge for over a year. I had the opportunity to tell him how much he helped our family. This experience ignited a spark in me, planting the seed for a future in family law. After graduating from law school, I began my legal career volunteering with Neighborhood Legal Services and volunteer Partners for Justice, Senior Partners for Justice, representing low-income individuals in family law cases. Here I saw families struggling with issues of financial insecurity, domestic violence, substance misuse, and behavioral health issues. I understood those struggles. I saw and learned that none of my clients would have been able to navigate our complicated judicial system of rules, forms, and procedures for representation. I then entered private practice and continued representing clients with family law matters. My career as an advocate ended when I joined the probate and family court, and the rest, they say, is history. On February 26th, I will celebrate 18 years serving the Commonwealth. The probate and family court is family to me. Its greatest strength is in its employees. Court employees who not only care about each other, but about the community they serve. They're hardworking and loyal. To do their job well, they must know an extraordinary amount of information, as our jurisdiction spans from cradle to the grave. For the last 18 years, I've dedicated myself to not only knowing the family side of our court, my roots, but the probate side. This is not an area many study in law school or gain experience in legal practice. It is, however, one of the most important responsibilities of our court to decide if an individual has lost capacity to the extent that they will lose their civil rights and someone else will be appointed to make decisions on their behalf. Appointments that can last a lifetime. If I am confirmed as an associate justice, I vow to embody the principles of fairness, empathy, and respect in all cases. I'm committed to listening carefully to all sides, considering evidence thoughtfully, and making decisions that are just, timely, and understandable to all litigants. This is the very reason, counselors, that I wanted to become a judge, and the only reason why I became a lawyer, to have a meaningful impact on the families who come into the probate and family court, the people's court, during some of the most difficult times in their lives. Thank you for your time. I hope you will support me to be an associate justice in the probate and family court. I'm happy to answer any questions you may have.
Thank you. Councilor DiPaolo.
Thank you, Counselor. Good afternoon.
Good afternoon, Counselor.
Congratulations on your nomination. We, as a council, received a lot of letters and calls on your behalf, and I just want to mention one that came in at the end of last week that I don't think is in our printed packets for the council this morning. That's from a friend, Chris Mena, who spoke extremely highly of you. So you did a lot of work, as we heard, on the MUPC transition, I guess. Would you say overall that that was a positive development in the law, in Massachusetts probate law?
Definitely.
So I just want to ask, what would you identify as some of the biggest improvements that came with that?
Great question. From my perspective, it increased access to justice because it offered procedurally an easier way to get a personal representative appointed or to probate a will. It's called the informal probate process. That had never been in Massachusetts, and it was incredibly valuable.
And so years later now, are there areas where with your judicial or practicing magic wand, you would like to see further improvements to access to justice?
Definitely. With regard to probate, definitely. More on the guardianship and conservatorship side, for sure.
What would that look like potentially? Or what would be some things specific that might make a difference for families?
I think on the guardianship side, as far as having the Massachusetts probate code with the guardianship and conservatorship of adult sections created procedural safeguards. And I think there could be more procedural safeguards in that area. I mean, one of the things that currently exists is that in order to appoint a guardian for an adult that maybe or is incapacitated, not only does a judge have to find they are incapacitated, but also that there is a less restrictive alternative. And I think that's really important.
Thank you. I hear from practitioners in this area a lot. Two things they mainly come to me about. One is probating estates and complex financials and business valuations. And we heard a little alluded to this morning, and I've heard that this is something you're coming at with a great skill set, and I think it's important for the probate court. And then the other thing that people come to me about tends to be around survivors of domestic abuse and things that are going on in conjunction or in the background of the things appearing in your court. And I'm wondering, you have experience with it for sure, dealing with folks. As a judge, what's your sensitivity around litigants who might be facing kind of non-physical harassment or coercion or, things that aren't directly in front of you, but that inform the situation?
Thank you for that question. Coercion is now in Massachusetts, it's incredibly important, obviously. Massachusetts legislatures, they think it's so important that they amended the definition of abuse to include coercive control. And so, I have seen abusive litigation in the court system, and judges definitely have a way to handle that. So as far as, what would they do?
Well, let me jump in then. So if we're looking at many of the litigants, not all the litigants in certain areas that the family and probate court deal with, are experiencing or have experienced trauma, whether it's the kids, whether it's the litigants. So I guess what are some things that you think about that create that welcoming, trauma-informed courtroom?
Trauma, we see in the probate and family court, we see cases where trauma is evident. And so the probate and family court is a trauma-informed court. And I believe our judges, from their lens point, understand that. We have a tremendous amount of training on trauma. I've attended several trainings on trauma and how that may exist in an individual.
What would be a good way for what would be a strategy for the court to address that proactively? Because we don't know the trauma that's going on with that. I mean, what would be, I'm just wondering, all of our courts, I think, are doing a good job of being sensitive to this. I'm wondering, what's an example as a judge, something the judge can do in the courtroom culture that would create a universally welcoming environment?
I think being kind, you can never, the first impressions are important. And so when I think people walk in the courtroom, Many people walk in, it might be the first time they've been in our court, and they walk in and they're petrified. And so I think when the judge is not what they expected, whether, meaning that they're kind and warm and welcoming, I think that goes a long way. I definitely think that goes a long way.
Thank you. I appreciate your thoughtfulness. I have no further questions, Mr. Chair.
Thank you, Counselor Jacobs.
Good to see you. I think I have two areas. We did talk a great deal about your background and many issues surrounding probate family court. One that we didn't get to yesterday, but I told you I'd probably bring it up here, is I would love to hear you speak to the elder grant and what that entails. It sounds like there's a grant, there's a second grant. I'd like to understand sort of the overarching mission or concise description of what that's all about, what the purpose of that is, what issues that's intended to alleviate, how long the second grant extends for, and what you think the future of it is and should be.
Thank
A
you.
lot in one question, but
That's
I
okay.
want to understand the thought.
Thank you. I appreciate that question, and I love talking about anything related to the Elder Justice Innovation Grant. Massachusetts in 2021 was one of only 7 states to receive this federal grant. And it was a unique opportunity because it was the first time, well, not the first time, but the first time, one of few times that the federal government actually gave money to state courts for the sole purpose of improving oversight of guardians and conservators of adults. So it was quite an honor to be one of 7 courts to get this type of funding. What we had proposed as part of our grant was to consolidate the oversight of guardians and conservators, specifically the filing of their reports required every year. Guardians, for those of you who are not aware, are trained for adults when they are unable to make personal decisions for themselves. Conservators are appointed when an adult is unable to make financial decisions and there's property that needs to be protected or gained. So we have created and just launched last week as a result of this 3-year grant, the Office of Adult Guardianship and Conservatorship Oversight. And they will be doing the monitoring of the filing of statutorily required reports. And that will ensure that the court is covering or making sure they're reviewing and ensuring that the adults under these arrangements, their well-being is protected. We've also, as part of the federal grant, we were required to collect data on these case types. And that's something that many state courts in the United States cannot report out their data. They cannot tell how many individuals are under a guardianship or a conservatorship arrangement. So as part of this federal grant, the federal government is very interested in that data because if we know who's under these arrangements, we can do a better job of protecting them. So this office is going to consolidate among all 14 divisions the review of guardians care plan reports and do it in a much more timely manner, and ensure that guardians and conservators are meeting their statutory obligation by filing what is required under the law. That grant will end in August of this year, so it's been almost a 4-year grant. I was asked to apply to the second opportunity from the Elder Justice Innovation Grant this past summer. I never thought we would get it because I thought, well, they're just so kind to us for the 2021 grant, but they did. So we were one of a few courts that got a second Elder Justice grant. And our proposal as part of that project is much different. And that proposal, which is a 3-year grant, is to take a deep dive with our partners, Department of Public Health and many others who agreed to be a part of this, and partnering with National Center for State Courts, and take a deep dive into the guardianship situation in Massachusetts and find out what's missing in the community. It's a diversion. We're looking at how we can guardianships. And part of that, again, is working with National Center to see what's missing in the community such that the person's only alternative is to come to the court and then have these incredible fundamental civil rights removed. most often never returned. So that's an important project to really undertake, especially as you heard from my witnesses, that Massachusetts has a very aging population. And we are talking about individuals, also not just older individuals, but individuals with an intellectual and developmental disability end up being subject to these arrangements.
Really appreciate you articulating all of that. So I wanted to hear your thoughts around the practice of probate and family court in keeping cases with a particular judge over the lifetime of evolving issues. So from divorce to maybe custody modification or support, whatever continued actions there are for the family staying with a specific. What do you think are the benefits and what do you think are the challenges or difficulties or problems of that practice?
That is an excellent question. The benefits I would see would be that judge really knows that family. And you're not reinventing the wheel by having another judge have to get up to speed on a particular case and the details. I think that's incredible. I know other states do that. I saw it during COVID with Oregon, for example, and I was so impressed with the judges actually knowing the names of these individuals that are under these arrangements. That was impressive. The problem, let me rephrase that. The challenge that could happen there would possibly be if that judge has a bias from the get-go, implicit or otherwise, and now you have a situation where that's following the family for possibly a long time.
Are there remedies you would suggest in that instance?
I'm sorry?
Are there remedies that you would suggest in that instance? If that's a good example. So if there was an implicit bias that's impacting the experience of the parties, and now it only can escalate potentially, right? Is there a remedy that you maybe should consider?
Remedy, first of all, I would say that, judges are often trained or are trained on bias, often. I think the judge has to always keep checks and balances on their own implicit biases. We know we all have them. If you don't really deep into it, if you're not conscious of it, I think that runs afoul. So, obviously, litigants have the right to file to get in front of another judge if they saw something. So that would be another.
Is that always honored if a family does petition to change judge?
If it was done, it would have to be reviewed. But it doesn't mean that the judge has to recuse themselves.
I appreciate that. So when you consider, this is a change of topic, but I'm curious to hear you just articulate what you see are, and we've definitely heard from witnesses, and there is, as Councilor DiPaolo mentioned, a stack of glowing letters that have come on your behalf that have really outlined for us. But I want to give you the opportunity just to speak to in your own self-perception, your greatest strengths that you'd be bringing to the bench, and areas where you see a potential area where you have both learning to do or challenges that you might face while getting to be under them.
As far as my strengths, obviously, I'm going to say my knowledge of the Massachusetts Uniform Probate Code, all 300 provisions that I've read 8,000 times over and over in the last, 15 years. And that's a given. Also the Massachusetts Uniform Trust Code, my knowledge and of the court system itself. Worked in this system for 18 years, not just in one area too. I've worked in pretty much all areas. So I've been in the registry, which is the department that takes the pleadings in, and the register is the custodian of the records. So I understand procedure. I've created a lot of procedure. Most forms I've created on the probate side, some on the domestic relations side. Most recently, I revamped our education program, which was a complete revamping to take it from a 2-day in-person program to an online, self-paced, evidence-based program. So I have, my strength is in identifying problems and finding solutions. My strength is also my knowledge of family law. That's my roots, as I said. I started out as a family law practitioner. That is something that is definitely my strength. I think everybody has a weakness to some extent. And I would say, that there's one case type that comes before our court where people actually want to come into the probate family court, and that's the adoption, National Adoption Day. And so I have never done an adoption. I understand the statute, but I have never done an adoption, so I would want to, brush up on that.
Thank you. I have no further questions.
Thank you very much. Council Brown.
Thank you, Mr. Chairman. We had a very lengthy conversation the other day. I know my counselor to my left here is a huge fan of yours for many, many years, and that means a lot to me. And I read through like you just killed so many trees with all these letters. And the thing that jumped out at me is like your average supporter is about 80 years old and still practicing. Does anyone ever retire? All the letters. I've been practicing 46 years, 45 years, 40 years.
Hey, Joe. I've been doing it 41. Come on. I know longer. I think we're gonna have to talk to you after this.
All right, I have no other questions. I'm voting for you next week.
Council Civil.
Congratulations on your nomination.
Thank you, Counselor.
And we had a wonderful conversation the other day so that I can get to know you better. I would say that you're the backbone of the probate family court, and you're going to have a tough time filling in your position. But also what I love about your experience is that you've been in so many different departments. Council, when they come before you, they won't be able to pull a fast one. And I think that is so awesome because of your extensive knowledge and the training that you've done with judges, not even being a judge yourself yet, and training other members in the court system to make sure that they are following all the guidelines. So that is a very positive trait to have. And also, you've been working for the probate family court for 18 years. As an attorney, you could have been like, enough is enough. I'm going to practice and I want to make more money. But considering the fact that you have so many people from all walks of life coming to you from this area, that area, you remain steadfast to continue to do your job. And that's one thing that I admire about your work and your experience. And not only that, you have a lived experience that helped you to remain where you are so that you can be an impact to people that you serve in the community. And I think I just have two questions for you, which is based off of bias and fairness. Community members may worry about perceived or actual biases amongst judges, particularly in cases involving child custody cases. What will you do to make sure that community members feel that you will be fair and impartial?
Thank you. It's a great question. Thank you for your kind comments. That was very nice.
Sounded like a yes, but I'm not gonna second guess it. Go ahead.
Yeah, everyone has biases.
Right.
If you don't know that, if you don't acknowledge that, that's the problem. I will constantly check myself as far as, am I biased in any way? I mean, I am not a biased person, but I'm sure I have a bias somewhere. I think, I'm conscious of that, and it's important to me to be fair because that's what we're about in the probate family court. It's the people's court. I've said that. I believe that. And you want individuals to come into the court and feel like they've been heard, feel like the decision was fair, and understand the decision. Sometimes that can be a challenge, making sure you write simply and clearly for people.
Right.
Individuals may not like a decision I may have to issue, but I promise you they'll understand it. And I hope that goes a long way so that they understand that this is a fair system.
Thank you. And my second question would be access to resources. I know that we had a discussion about domestic violence and, you know, those who come from immigrant population that don't speak the language, making sure that interpreters are available. I know that you've worked in several different departments and, you know, myself for the last 10 years, there are times where the courtroom or the judges may be bombarded with a lot of people, with a lot of cases, and they like to keep it pushing, they like to keep it moving. What would you do differently if someone, a woman or man that is impacted by domestic violence or involving children, or someone who doesn't speak English? What steps would you make to make sure that, one, the court is cleared and that it's a sensitive issue, making sure privacy, even though it's a public courtroom, making sure that this person feels welcomed and making sure that, you know, that we can step the cases back to provide the interpreters that we need for this particular individual.
I think anytime a plaintiff comes into the probate and family court on the issue of an abuse prevention order, that's a difficult day for that person. So there are great resources in our court to assist that person as far as having support with them. So if I saw somebody that was not had a support person with them, I would contact the court service center and try to, or the advocates within our court, and try to have that person come up and help this individual. As far as language issues, we have in our executive office a language, it's OLA, so it's an Office of Language Assistance, and so you contact them to get a translator for an individual. So I would make sure I did that. What happens sometimes in the real world, if there's a particular language that they need, an interpreter that they need, if it's unique, it can be problematic. So in that situation, what I would do is I would, if they can't get an interpreter for me, there is a language access line that we have. So I'd contact the language access line. If that didn't work out, I would, and the person, so let's say the person had somebody with them, I would see if that family member would be sworn in and interpret for them. Worst case scenarios, you get none of that. What does a judge do? You go, anybody in here speak? And you look for that resource, and you go from there. If I had to, if this was a case maybe that involved abuse, anything that would be incredibly difficult with children, you cannot close a courtroom unless a statute allows that. But one of the things a judge could do, and I've seen judges do this, is say to everybody in the courtroom, I understand that you're all waiting for me to hear your case, but as you can tell, this person has some sensitive issues, and although I can't force you to leave, if you could give this person the time to have some space to talk to me, and so I can hear their story and get the facts I need to issue the order. If you could just go out in the hall, give us 5 minutes, I'll try that.
Thank you. Thank you. No more questions.
Thank you very much, Councilor Dolan.
Thank you. Evelyn, I'm so emotional. I didn't know I was gonna get this emotional. I want to explain to people why.
I think she might be a yes too, I'm not sure.
Evelyn was my classmate in law school. And we had not seen each other since we graduated until this week when we met at the Concord Library to talk about this hearing. And I'm so proud, and I remember what you were like, and we were pretty much identically situated at the time. So I can speak personally to how challenging it was and how hard you had to work. And so I'm incredibly proud of you. And I want the folks here who've had the pleasure of working with her for many years, which I haven't had, but didn't know what she was like in law school, and I did. And all of the qualities that we're hearing described were very much evident then. You were a very diligent student. You were a dedicated mother. You had an excellent temperament. You had good judgment, all those things. And so it's incredibly powerful to see what you've been able to accomplish. I'm obviously going to vote for you. I have just a couple of questions, though. We had talked about coercive control, and that's manifested in a variety of ways. And one of the things that some folks do is abuse the court system in order to exert control over their victims. One of the techniques is known as bankrupting the other side, just playing everything out as long as possible until the other party is emotionally and financially exhausted into settling in a way that isn't necessarily in everyone's best interest. What would you do as a judge to deal with coercive control through the courts?
Thank you. It does happen. We see it. There are some cases, you know it, when you open up, the case management system and you see on the docket over 350 filings or whatever, there's something going on there. If there were lawyers on the case, I would get them in the courtroom and find out what's going on to try to see how I can help them stop this. That's not always the case. Oftentimes, you have one side that's represented and the other side is not represented. That's very common. And it's the side that's not represented that's actually being the coercive controller. It's driving up the legal costs for the other person. So one of the things I've seen our judges do that it has been effective is what's known as a gatekeeper order. And that just means, and it's right on the file, that means you can't, the person who is doing this abusive litigation can't file without the court first looking at it and saying it's okay to be filed. It's not that we can't prevent somebody necessarily from not filing, but that's like a review before filed to make sure it's not frivolous or being used as a tactic as you described. The last thing I think one other thing I've seen judges do is if there are a bunch of motions, for example, being filed in a case like that, instead of having those motions heard this day, that day, this day, consolidating them into one day. So now you've got, especially if there's lawyers involved, only one trip to the courthouse, one expense for that person. Those are the things that I've seen.
Just one other question. I was really glad that you raised the issue of adoption because that is an instance where people are really happy to be in probate and family court.
The only instance.
It's the only instance, but in most instances, it's incredibly stressful. It's incredibly difficult. You certainly have situations where someone who has been abused is facing their abuser in court. What will you do as a court, as a judge, to try to make that process as little traumatic as possible?
I think as far as, what a judge can do is ensure that that individual, if there's an abusive situation going on, as I said earlier, have some moral support with them. I would definitely not send parties out to mediate, go to probation. That's a no-no. That doesn't happen. That's a no-no. But, if both parties, if they're before me, they're there for a reason. And so I would want to make sure that I gave them the time to tell me what is going on so I could help them and issue a decision that would help them, depending on what it was.
Thank you. And I know that Counselor Kennedy is extremely enthusiastic about you. I think I may be even more enthusiastic than he is. And I have no further questions.
Thank you. Thank you.
I know.
Thank you very much, Mr. Chairman. It was very nice. I enjoyed speaking with you last week. When I had hung up the phone call, I said, this one was great. She's good. And as I sit here today, you're outstanding. You're the real deal. It's good to see the chief here, strong supporter. Nobody's better than the Chief Justice. He's top shelf. His assistant Dominic, I think he left. Yeah. Judge Roberts, you have a lot of support here. Temporary orders. I understand, I don't do divorce, I don't do, temporary orders. If somebody files for divorce, then at some point they come before, both parties come before a judge and the temporary orders are issued, correct? Generally speaking, I know circumstances change. About how long does a hearing generally last on the issue of support and let's call it a parenting plan?
Well, they're all different. It depends on the facts of the case.
That's what I'm saying, which generally. and let's leave it so nothing's agreed upon.
They're scheduled for a minimal amount of time, around 15 minutes, but that doesn't mean that that's what the scheduling is. It doesn't mean that's what the judge gives them. The judge doesn't, just because they're scheduled for a short period of time, doesn't mean that's what happens in the courtroom, reality.
No, I understand that, but I'm saying, in your experience, judges, it usually takes, you get what it says on a piece of paper. Oh, it takes generally 10 minutes, it takes 2 hours. What's your understanding? Generally, try to get a sense. I'm coming to a point, that's why I'm asking you.
Well, I would, as a judge, I need to get enough information so I can make a decision. So it's maybe, I get that information in 10 minutes, great. Maybe it needs a half an hour, maybe it needs 45 minutes. So, you know, every case is different.
Okay, no, I get that, but, you know, I'm a strong advocate for the children. You know, the support, it is what it is. So let's go on the high side, let's even go a little higher than you said, let's go an hour. So each side, I know it doesn't work quite this way, each side has a half an hour. Okay, well, I'm representing, doesn't matter which one, okay, I'm gonna go 15 minutes on the support issue, 15 minutes on the parenting plan. Oh, man, that's, and then the judge may ask questions, you know, I can't tell you how many stories I hear, again, the parenting plan. You're gonna make a parenting plan in what I call, you know, a real short period of time. We're talking about kids 7 to 10 years old. One parent lives here, one parent lives 20 miles away. They have sports, and the other one doesn't have sports. That's a lot of pressure, and if you get it wrong, again, I don't do this type of work. What's the next thing that happens? You have to wait several months before they come before the modification's not the right word, we're still the temporary orders.
Yeah, another motion.
You have to wait for a divorce, and that could be years.
They could file a motion to change the parenting.
Yeah, but lawyers charge a lot of money.
I know, that's why I think that it's important for the judge to spend the right amount of time and not get it wrong.
Yeah, I just myself, if that's the biggest, and I don't know the answer, because there's a lot of cases.
Yeah, there is.
You give a parenting plan, so again, I don't care about support. Oh, that's tough. So with respect to a parenting plan, we talked about this. Now you have 2 people. Let's count 1 to 10, they both attend, the mother and the father. But they live like 15 miles apart, and they're 7 years old and 10 years old. Great parents, but they both want both kids 100% of the time. Yeah, it'd be unrealistic, but that's what they want. So it's not any agreed upon, you know, you gotta make a decision. Without knowing more about the facts of the case, what's your gut tell you? What do you want to do, if at all possible?
Well, we know that children do best when they have relationships with both parents. In the facts as you described, meaning it's a healthy arrangement. We're not talking about any abuse issues going on or anything like that. So children do best with a relationship with both. So from my standpoint, and I acknowledge that, I would want to see the kids with both parents. I mean, you can't physically split them up, but so I think, you know, you can make sure that they have the, you know, same amount of time with both of them, let's put it that way.
Okay, whatever that means. To me, and tell me what you think, to me, and it has been done, I'm in favor of a 50-50 split. With all due respect, and I think you're great. I don't know what the all times, maybe that means 70-30, maybe it's 60-40. To me, I like a 50-50 split, okay? And again, if possible, 15 miles apart, they go to the school here, they got sports afterwards, you know, you don't want to have, I wouldn't think, one parent on the weekends all the time. I'm talking like, what do you think? Like Monday, Tuesday, Wednesday, then Thursday, Friday, or Monday, Tuesday, 4-3, 3-4, 4, you know, split the vacations in the summer, because we got great parents.
Yeah.
And they're really flexible
Yeah.
with their time. Every other week, you know, That's what I like, because you know what, at the end of the day, you can relate. You know, it's important. You got a kid 7 and 10, reading him a book or reading her a book, watching a movie with a child, just taking a walk, going, I mean, so that's where I come from. Tell me more, I think I know, because we had a fantastic conversation. Tell everyone here what is the ideal for you, but as specific as, I was pretty specific.
You are.
Where do you come, where are you from?
To the extent I could do a 50-50, of course I would. That would be my starting point. Would be my starting point. That's when I said, you know, I can't split the kids, but when I was thinking equal, I'm thinking in my head, if you want to do a percentage, I would say 50-50 is the starting point.
Yeah, no, that's good, because it's, you hear so many stories, you know. Yeah, 50-50, I don't want to belabor it, but without a 50-50, you have,
Sorry.
sometimes I hear situations, and I don't do this type of work. But oh yeah, I was supposed to see the kids Thursday and Friday, but I called so-and-so, the ex, and so-and-so's sick. I gotta wait another week. You know, what do you do in those situations? Kids get sick, I get it. There's emergency situations. And again, if a lawyer comes before you because of, again, I mean, let's be saying this right, for a contempt, that's gonna cost somebody some money. These lawyers charge a lot of money. What do you do to enforce whatever orders you get? Again, I'm just talking about the parenting plan. But you see, it's not working the way you thought it might work or it should work. What do you really realistically do? You're not gonna find someone, I wouldn't think. You're not gonna put them in jail. What do you do?
The evidence came before me in a situation like that, where you said there's, you know, contempt filed. If the evidence was there to prove that there was disobedience of the court order, I would make a finding that they're in contempt.
And what does that mean?
That means that they disobeyed the
No, I
court.
understand it, but I don't.
I hear what you're saying.
Yeah.
The most important thing, so what does that mean? You're right, because one side already, you can never go back and give that child the time that they were supposed to have with that parent. But you can use it as a tool to instruct the other side, the contemnor, the person who is not following the court order, to let them know that you can't on your own take matters into your hand and not follow the court's order. So I look at that as a teaching point, because what you don't want to do is have parents keep coming back. You don't want contempt after contempt. So that's where I would go with that.
I appreciate that, but what's the repercussions? So yeah, what happened last week? I got a contempt. What happened? I got a contempt, but like,
That's what
so what?
Right, so that's what I'm talking about. The remedy part of that would be to let the person who is violating the order know that you're not going to allow them to do that to the other parent. And it could end up being a custody change.
Okay, before I forget, your counselor here, Counselor Kennedy, strong supporter of you. He's a strong supporter. I gotta tell you, this is the toughest question. I wasn't gonna, I had no intention of asking this question, but you're so good. You're like us. You're like a star. And I've been here a few years. I don't ask this question anymore, because I don't know, 99% of the people sitting in there, they don't get it right. They go, what do you think? Should I ask her? You're close with it. Let it go? Sure. Ask her or let it go? Yes. Okay. This is like a game show now. It's like,
Do I get to phone a friend? I've got a bunch of judges over there.
what do they call it? Like, what the hell they call it?
Yeah.
Public administrator. What circumstances would you appoint a public administrator? And tell us what you know about a public administrator.
I got you. Oh my God, this is the best.
Gave her a softball. That's what she does.
Okay, this is the second probate. So under chapter 194,
Go ahead.
it is still in existence, the
Go
MUPC.
ahead. I was a public administrator for 25 years. That's why nobody, okay, I'm sorry.
We
Yeah.
need more public administrators. We have a shortage, by the way, in some counties, which is a problem. So a public administrator is when there is an estate, you have a decedent, first of all, you have to have the decedent. And then there's no family coming forward to probate that estate, but it's needed for whatever reason. And so the statute allows this public administrator to come in and be that person,
Yeah, to probate these things.
probate the estate.
Yeah, it's actually, in every county but Middlesex, there's 5 public administrators per county, except Middlesex has 6. And they're actually officially, in the beginning, appointed by the governor for a 5-year term. And then if they file a petition, then the judge, like you said, would appoint the public administrator. I give her a correct answer on that. Excellent
Good, good
job.
for you. Thank you, Counselor Iannelli. You all set? Oh, I'm sorry. I thought he said it was the last question.
It was the last question. I want to say something.
Please
Okay,
do.
I'm almost done. Fantastic. You're gonna be a great addition to the probate and family court. Like I said, great conversation we had. I wish you the best. Look at that. You got 2 girls there. That's a success story.
I know.
To get your career, you just look at them. You did a great job. And that, to me, is the real success story today.
Thank you so much. Thank you.
And I know Counselor Ziegler has about a half hour worth of questions.
Thank you, Chairman. Actually, this body did a great job and asking a lot of the questions that we had the opportunity to discuss when we spoke. So congratulations on your nomination.
Thank you.
So much for putting yourself forward and for also taking the time to speak with me and allow me to get to know you through our conversation. And it was a great conversation at that. You know, our conversation, we spanned a number of topics from, you know, your focus areas that you would bring to the bench, your professional development opportunities, your accomplishments, what you look to accomplish. And I really enjoyed your intentionality in the way you answered my questions. And I wanted to bring out a couple of those responses that you had given. I want to preface this by saying that, you know, it's not often that we'll have a candidate that has all this experience on both sides of the court, right? So I appreciate that you bring that lens of both family and probate to the court. And I thought that it was refreshing. I know my colleagues had mentioned this already, the letters that we received. And I counted them out and we received about 18 letters. So it's like a letter for every year, which I thought was very impactful.
Yeah.
And the fact that these weren't like 2-3 paragraph letters, they were 2-3 page letters, right? Of folks really wanting to express to us how thoughtful you were in your approach, your knowledge base, the fact that you would be a great addition to this position. So that does carry a lot of weight with me, and I do take that seriously. So kudos to you for garnering that support. And so we talked about a lot of your accomplishments, but I wanted, you know, to dig into that a little bit. What would you say is the accomplishment you're most proud of in this work? And what would be your top priority to accomplish should you be confirmed as a judge?
Thank you for that question and for those nice comments. I appreciate it. I'd love to read the letter. Just kidding. I have been privileged for the 18 years to work on many, many different projects, especially in the administrative office under 3 different chief justices. And I'm not so sure I could pick one over the other because they've all had an impact on the public. And that's been important to me. I've been so lucky to be able to change the parent ed program. And I know that benefits parents. I know they're getting a good program that's evidence-based. They can do it on their own time. They don't have to go out and spend 2 days at sessions. That meant something to me. Being a part of creating and developing the fiduciary litigation session, which is an access to justice resolution or a response to an access to justice issue. That has been incredibly meaningful to me. You know, I could go on and on. Work I've done, the mother-father workshop that I did with, at the time, Counselor Tito Jackson, and what we did at the mayor's office to help families that just wanted some information on getting child support. And that meant something to me. my work as a family law facilitator, sitting down and talking to parents and helping them carve out a solution to their problem, that meant a lot to me. These all have meant so much to me, but at the end of the day, it's been my ability to help people. That is the only reason why I said in the beginning I ever became. And it's one of the best things I've ever accomplished as far as for 18 years being a public servant. What I hope to see in the future for the court is I really hope to see probate, you know, a little bit more attention. I think, you know, we have probate judges, we have had many in this room, actually amazing probate judges in this room. And that's been wonderful, but those probate judges are retired. And so we're at a situation where it's critical that we put judges on the bench who have that base. Right now, what we've done is we've brought in 2 judges. We gave them 1 day of retirement and said, we're dragging you back. And, you know, that's, I don't think we can sustain that. So it's really critical. Probate case types, there's families behind those case types, families that are trying to probate the estate of a loved one. I mentioned the guardianship and conservatorship cases. That is at the heart of my interest in making improvements, because you're removing fundamental rights from individuals. You know, there needs to be a judge that understands all of that information, understands the law, understands how they can limit the removing of certain rights. So that's what I would like to see.
I appreciate you listing that out, and even in our conversation, you listed out other things as well as to some online programs that you worked on regarding guardianship and conservatorship. And in one of the letters that was called out, and an individual said that you launched a new program like 10 days ago. So this is fresh. These are things that you're actively doing while you're a candidate for this process. And access is, you know, very important, right? And that's something that really resonated as we spoke. We also spoke about strategies in which you could reduce harm from the bench. And I know you spoke about that a little bit earlier today when one of my colleagues posed a question, but I wanted to dig into that a little bit more as our conversation centered around using a trauma-informed lens and how you would, you know, truly change the environment within the courtroom. Can you speak to that a little bit more?
As I mentioned earlier, we see trauma in the cases that come in the probate and family court, and sometimes they're overt, sometimes they're not. It's sometimes not necessarily clear what trauma the person has experienced, or if they experience trauma. You might see it with an individual not being able to look up at the judge and maybe not feeling secure enough to talk about and tell the judge their story. And then there are other times where you see trauma really come out in outbursts and things like that. And so I think as a judge, you have to be incredibly mindful of trauma, what people have experienced, perhaps even from childhood. You know, we know with the adverse childhood experience study that trauma that children experience early on can go on into adulthood and be exhibited by certain behaviors. So if I were to see trauma occurring or an outburst in the courtroom, my first thought would be, I need to calm this down. I need to bring this down. That would be me addressing with the individual that's having an outburst and letting them know that I want to hear their story so I can make a decision that will help them, but I won't be able to hear it if they're screaming or they're just not, you know, they need a break. So I'd make sure that I was able to give them a break and call that case, maybe the second call or something to that effect, and then see what I could do to help that individual. I think judges have to be mindful of the entire courtroom and making sure that you know, everybody who's watching this, is also not getting traumatized by that particular experience. So it's keeping everything, in line.
Thank you. I appreciate that. And I appreciate your answer and your diligence because, you know, this is a position that holds a lot of power and a lot of weight, especially, you know, around folks who may be fragile coming before the bench. And so I do appreciate your intentionality around how you frame that. And we also talked about, as I said earlier, professional development and your commitment to continue to learn and educate yourself on new research and policies that may be coming down the line in order to ensure that you're making the strongest decisions from the bench. So I thank you for your time. Thank you for putting yourself forward. And those are all the questions I have.
Thank you very much. I've only got about an hour's worth. We spent a lot of time in my office. We had a very, very long conversation. It was a delightful conversation. Everybody's answered all the questions. I agree with everybody describing you as a superstar. You are. I look forward to putting your name in nomination next week, and we're done. The next hearing Congratulations on your nomination. Right, this is a letter from the governor dated January 22nd, 2025 to the Executive Council. I am pleased to nominate Sarah Turano-Flores to the position of Associate Justice of the Land Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. Have you ever read that? Me either. I'm enclosing the nominee's resume for your convenience. Okay, present at the moment, we have Councilor Ziegler, we have Councilor DiPaolo, we have Councilor Jacobs, we have Councilor Ferraro, we have Councilor Civil. Councilor I know will be in a minute, Councilor Dolan will be in a minute. We've been doing hearings for the last hour and a half or so, and sometimes people have to take 2 minutes for a break. Okay, so why don't we start by having you introduce the folks you brought here with you?
Thank you very much. Good afternoon, councilors. To my left is the Honorable Roberts, retired Justice of the Land.
Judge Roberts, well, we approved her.
Also, with me is my ex-husband, Michael Flores, Jamie Proctor, and Valerie Moore, our colleagues from Nutter. Liza Cox is my dear friend and colleague and my second witness here.
It's nice you have a friend. I hope to get one someday.
Probably not.
Colleague Shackelford's another dear friend. And at the end are my daughters, 2 of our 3 children, Adalia and Liliana Flores.
You guys ready to call your honor at home? Maybe not at home. At home, judge might be good enough. And you have to be nice to her. She can put you in jail.
I should say my son can't be here today. I don't want to forget him.
On YouTube?
Aurelio's watching.
Talked about that he'd be on YouTube.
Yes.
All right, very good. All right, we're gonna start with your first nominee who has been now retired, which kind of freaks me out because it seems like you were just here. Jennifer Roberts, Associate Justice, retired of the Land Court. And Judge, we just asked you to remember the most important law of the land, the law of brevity.
So.
Thank you.
Councilor Ferrera, who's my counselor when I came through this process before, told me that if I said Sarah Turano-Flores is excellent and sat down, that I would, I seated, but that to your purposes. I'm going to say a little bit more than that, but not much. I've known Sarah for decades now. She practiced on the Cape. Some of you may recall that I lived at practice on the Cape for many years. So I've certainly known of her for many years. Had the occasion before I became a judge to recommend her to clients because I needed somebody with a certain expertise in Wetlands Protection Act law, which I'm sure you're all familiar with. She was the name that kept bubbling up as the person who was the expert in that. And so I was very comfortable recommending her to my clients. Shortly after that, I went on the bench and Sarah appeared in front of me a number of times on a number of different cases. Several that I come to mind immediately involving pretty complicated real estate matters, land registration matters, a big development up in Andover, a multi-phase condominium, the golf course kind of thing. And everything that she did, every case when she was in front of me, she was just superb. Her knowledge of the facts, her knowledge of the law, her legal analysis, her written materials were just not, you wouldn't find better. So I have thought for quite a while now that she would be a wonderful addition to the land court bench. The last thing I'll say about her is that in my observation, she has always displayed what I call the ability to disagree without being disagreeable and to treat her opposing counsel with respect. And I think she has just the kind of temperament you would want from a judge.
Don't you think she has an issue with judgment?
She asked me to be
from the Cape to East Boston.
Well, there is that.
I'm supposed to go the other way.
There is that.
To me.
That is a good one.
Thank you, Judge. We appreciate it. Does anybody have any questions?
Judge, I just want to say thank you. It's nice to have you back here again. I'm sorry that you retired 10 years before you had to.
You're right.
Thank you, Judge. Next, we're gonna call Eliza Fox of Nutter, McLennan and Fish.
Thank you.
Welcome.
You. Good afternoon, Mr. Chairman, members of the council. My name is Eliza Cox. I'm really pleased to be here on behalf of my dear friend and colleague, Sarah. Sarah and I have known each other for about 19 years now. We first met in 2006 when Sarah joined the Cape office of Nutter, McLennan and Fish, and I was a junior attorney at the time practicing in land use law. Being a small office, Sarah and I got to know each other very well, both personally and professionally. I immediately admired Sarah's work ethic, her incredible knowledge of land use law, her curiosity, attention to detail. And she was one of the first people that I would turn to ask for help on cases. And I think I've probably asked her 1,000 times if she can have a second look at a case or we can discuss how to approach a particular matter. And she has never said no to me once when I asked for her help. And now 19 years later, we're both partners at Nutter, and she's still the first person that I turn to for a second opinion on how to approach a particular matter. And I know I'm not alone in seeking her help and assistance. And in fact, several of the other younger attorneys that she has mentored are here this afternoon. I'm also grateful to be here to support Sarah. We've also over time become the closest of friends. She is the godmother to my only daughter, and I have had the immense pleasure of watching her and how well she has balanced being a mother and raising her three incredible children. Sarah is really the linchpin of her family, and I will never forget, and I've had others mention this to me as well, how despite Sarah being the youngest of three herself, how beautifully she eulogized both of her parents at their funerals with poise and elegance. She's a lovely, thoughtful speaker. I think, though, one of the best ways that I wanted to describe the qualities and values that I believe Sarah will bring to the bench is to share with all of you a recent personal experience that exemplifies her compassion and humanity and incredible leadership skills. Last August, I was involved in a very traumatic accident that resulted in multiple surgeries, and I had to be in hospitals for over 5 weeks having surgery and recovery.
Okay.
Thank you, I am. I had spinal fusion surgery.
I'm sorry, Yanella, about it. I'm gonna give you his card. Are you okay?
Appreciate that. But Sarah was literally one of the first people I called when I was in the ambulance being taken to Boston for surgery. And the next thing I knew, she showed up by my side in the pre-op room to be there to speak to the surgeon and ask the questions that I couldn't think of given my condition. Not only that, but professionally, since I was going to be in rehab for a long time, and without me even asking, and despite her very busy caseload and schedule, she personally reached out to my clients, actively took on all of the cases that were very active or delegated them to other colleagues. And I can't begin to express the depth of my gratitude for her friendship, but also for her professional leadership in that time. So it's, without any hesitation or doubt that I think Sarah possesses the legal skills, the temperament and personal qualities to be an excellent land court judge. So thank you very much.
Thank you very much. We're all glad you're okay.
I appreciate that.
I don't think anybody should ask you questions. Thank you very much.
Thank you.
Okay. And that concludes the witnesses in favor of the nominee. Assume your daughters are coming up in opposition?
Yes.
Wow, she jumped right on that, huh? Geez, all right. So hearing none, we're gonna close that portion. The floor is yours. The statement.
Thank you very much. Before I begin, I'd like to thank Governor Healy and Lieutenant Governor Driscoll for the honor of this nomination and for putting their faith in me. It is truly humbling. Of course, I'd also like to thank my witnesses, the Honorable Jennifer Roberts and Liza, for their really heartfelt and moving words today. To have such brilliant and accomplished women speak on my behalf means the world. So thank you. I wanted to thank the Judicial Nominating Committee for putting forth my name and for their incredibly important work doing the first layer of vetting judicial candidates in the Commonwealth. Of course, my appreciation also extends to all the legal professionals who support the governor, the lieutenant governor, the JNC, and this council. including General Counsel Paige Scott Reed and Deputy General Counsel Dara Kesselheim, who's here today and have both provided me invaluable guidance along the way. And also JNC Legal Program Coordinator Kimberly Batiste and the Council's Administrative Secretary Valerie McCarthy, who kept me on the straight and narrow and made sure I was where I was supposed to be throughout this lengthy process. And finally, thank Councilor Kennedy for your guidance and sharing through this process, as well as all the councilors here for their hard work. It is amazing to me the amount of diligence you perform in carrying out your judicial confirmation duties, and especially the amount of time you each took to meet with me individually over these past weeks and the questions that you asked to help get to know me better. At this point in the process, I know you've already learned a lot about my professional qualifications and my land use related experience. So I just, not only from those interviews individually with me, but also the written materials that you have in my application. But I thought today perhaps you'd like to hear a bit more about my personal experiences that perhaps would lend well as if you all confirm me to be an associate justice at the land court. I'll start by saying there's a few things I enjoy less than talking about myself. So I hope you'll bear with me as I do this by sharing a bit about the personal lessons I've learned, important life lessons from the people I love over the course of my 30-year career. Important life lessons such as hard work, resilience, generosity, humility, compassion, empathy, selflessness, patience, and unconditional love. Again, all of which I hope will serve me well. Growing up with my two older brothers in Connecticut, our parents taught us the value of hard work and resilience. After serving in the Navy after high school, my dad was the first in his family to attend college at the University of Rhode Island. While he was progressing through his career, he went on to get his master's in education. He started out as a physical education teacher and progressed to become the director of special education for all of New London County. My mom grew up in Fall River, Massachusetts. She likes to tell us it was a cold water flat, and she did not attend college. Throughout my childhood, she worked full-time, raising all three of us and running the household. Grass never grew green under my parents' feet, as they strove to give us the best that they could provide. When it came to me, their youngest, they also had to balance working full-time, unfortunately, with the needs of a sick child. We lived in Lyme, Connecticut, and I contracted Lyme disease fairly early, which went untreated because at the time when I was 8, they didn't know what it was. So I relapsed again twice, and each time I was out of school for many, many months at a time. I watched my parents then balance the needs of their sick child with the demands of a full-time job. And those lessons served me well when my own child was born, needing emergency medical attention and had reconstructive organ surgery at 5 months of age. While I was in the hospital and for her lengthy recovery after that, the lessons my parents taught me about balancing my burgeoning career with the needs of the family stay with me to this day. I can't forget or go without mentioning all of the wonderful mentors throughout my career who have taught me the invaluable lesson of not only how to be a good attorney, but also how to be incredibly generous with their time and how to mentor the next generation. My first mentor, Edward Vieira on the Cape, spent countless hours chairing me during several land and superior court trials, and the trial attorneys among us know how much time that takes, and he always let me lead. He even second chaired me during my first appeals court arguments. At the time, I don't think I realized the amount of time and energy that he took to ensure that I became a good litigator. My next mentor, Patrick Butler, was managing partner in the Hyannis office when I joined in 2006, and he demanded legal excellence from all of us. However, the greatest lesson he taught us was to be forever mindful of our privilege and its attendant obligation to give back to our community. His example of giving back led me to join and to this day remain on the Board of Trustees for the Cape Cod Neighbors Fund, which provides critical financial assistance to individuals and families on Cape Cod who require housing, food, healthcare, and childcare assistance. Pat died suddenly in 2009, and it left an enormous hole in our community as well as our law firm. His lessons in humility, compassion, empathy, and how to lead first with your heart remain with me to this day. Of course, so many partners at Nutter, Michael Scott, Michael Leon, you just saw Tom Jalkett, Deb Manis, Paul Ayub, Bob Fishman, Jim Ward, Mary Ryan, Marshall, Julie Berry, Beth Mitchell and Mariana Jamie, and just to name a few, have always put their trust in me almost from the start, which really back in 2006 gave me the confidence to put to rest my imposter syndrome once and for all, and have confidence in my ability. And finally, there's an army of colleagues, friends, and family who have shown me only selfless support with no expectation of anything in return. Legal professionals and paralegals who I've worked with to make sure that I am organized and where I need to be. Christine Ford, Teresa Villa, Charlene Benjamin, Maddie Molina, just a few of them. My dear colleagues here today, Liza, Valerie, Jamie, representing so many former colleagues, and Holly representing friends and family, they have provided such selfless support to me over these 30 years. We've supported one another through personal and professional victories and defeats, celebrations of birth and devastation that follows lives lost, that mothered my children and covered my caseload through both my breast cancer surgeries and attendant medical leaves thereafter. They swooped in again to pick up the pieces when both of my parents died suddenly, 6 years apart, reeling each time. And it's not an understatement to say I wouldn't be here today without their selfless support. And finally, turning to Team Flores, sits here along the wall. I'm here only because of their unconditional love. During the last year of law school, I married my best friend, Michael. And we're no longer married, but he's my best friend here still today, supporting me with 2 of the 3 of our proudest accomplishments. It's been a long road, and the entire family has exhibited real patience over the years. As I was town attorney and a land use attorney, you're working all day, but you're also having to attend those night hearings and meetings, countless times miss bedtimes, meal times, games. That enduring impatience and unconditional love has supported me. And again, I think I could not have accomplished what I have without them. So those personal lessons, I think, are most important to me that I've learned over the 30 years of my career. I will strive to apply them if to confirm me. And in closing, I'll remind myself of the most important practical lesson I was taught by my first boss, who said, "Sarah, always know when to put the cap on the pen." And so with that, I will put the cap on my pen and turn it back over to the chair. And thank you for your time, and happy to answer any questions. Thank you.
Thank you very much. Councilor DePaulo.
Thank you, Counselor. Good afternoon. Congrats on your nomination. I have a very limited network of folks who've ever practiced in land court, small bar. But the folks I do know have, through their network, said really good things about you. Your application was really thorough, so I'm not sure really what I would ask of you. I used to be on the Worcester Planning Board, and
Thank you for your service.
thank you for showing up in the meetings, right? And hopefully you're able to bill while we're going on, whatever you're for. So I'm not gonna ask any questions. You come with impeccable recommendations, and I intend to support you.
Councilor Jacobs.
It's good to see you. I want to thank you for making the drive out and sitting down and having such an in-depth conversation that we ranged over so many personal and professional topics that I feel like I really did get a good chance to see who you are and get to know you, and I appreciated that. I do want to highlight that you are an alum. Your law school is Western New England, and we don't get to see that many Western New England nominees come through who aren't Western Mass based. So I give a thumbs up. And
That's gonna get you a yes right there.
had to say it. I appreciate that in addition to the breadth of your career, one aspect that you have in your experience is having been a solicitor, a town solicitor, and have that municipal perspective to kind of balance all the other things. And I'm not going to belabor it. We have another hearing coming up, so I don't want to take a ton of time, but I did want to give you a chance to just share your thoughts on that experience and how you think it will impact how you are as a judge at land court.
Sure, thank you for that question. Thank you also for taking the time to meet with me. I think the simplest way to answer that is it's the first time, and it was an early lesson that I had to be a lawyer and be completely neutral, which I think helps to be a judge. Your role as a town attorney is to give an opinion as to which way they should rule on a case. Your role as a town attorney should be to inform them of what the law is and what the possible outcomes should be. As the appointed or elected body, they should be making that decision. So, being an advocate and suddenly having to turn that off and being very neutral was something I really enjoyed. It surprised myself that I enjoyed it so much, and I think it will serve me well.
I appreciate that. I will just comment as well. We got a stack of letters in support that are coming from many Nutter fans, which is not surprising, but really above and beyond and extends to so many different types of backgrounds weighing in that they've experienced you as opposing counsel and they're in different professional. So all that to say, really strong support came in, and then I've heard feedback that is so consistent as well from my own network of people who've had experience with you, and the words that come up most frequently were calm, kind of person that can really bring down heated and focus on rational and find a way through, and just very complimentary. So
thank you.
I will end it there. I know time is of the essence, so I'll pass the baton.
Council Ferrara?
You have
Thank
General
you, Council
Roberts'
Ferrara.
recommendation that
Appreciate
means
your comments.
everything. When it says, great land court judge, and I'm sorry, I went 15 seconds more than I wanted to. You have my votes.
Council Civil?
Congratulations, Sarah, on your nomination. It was a pleasure speaking with you the other day. And I think you'll do a phenomenal job being a land court judge. The only question I have would be, can you explain your approach to ensuring transparency in land court proceedings?
Well, I think that we, as a single justice court where you have one justice assigned from the start, is a way of assuring that transparency, because within, I think the time standards say 90, but it's never gone longer than 45 days or so of the complaint being filed. You are in front of that judge who's assigned to that case and then follows the whole way through. And at that initial, we call it a case management conference, that judge has required the parties to come together and file a memorandum and really talk out the issues. And so, there's frequent check-ins throughout. Everything is, of course, publicly recorded during the proceedings. It's in the docket, the outcome. We request status conferences frequently so that as issues come up, you can get back in front of the judge. I think that's unique to the land court. That's not the regular practice in Superior Court. So that helps you, I think, throughout the process to feel that you're being heard. And of course, the clients, the litigants are invited in all the time at every step of the process, whether it's virtual or in person. So they feel as well that they know what's going on and can feel confident throughout that nothing's happening behind closed doors.
Thank you. No further questions.
Thank you. Council Dolan?
Thank you so much. I really enjoyed our discussion. Count me among the many attorneys who have no experience whatsoever in land court, and I really appreciated the way you discussed issues in a way that was very accessible. And I also want to say that, and then I just have one question for you. We talk about judicial temperament, which is really important, but judicial likability is critical. You have got that spades. I really enjoyed our conversation.
It as well.
Thank you. I want to ask you one of the things that I asked you about, which is that in the new presidential administration, we can anticipate a loss, terrible loss of environmental protections. So can you address what the role that our state land courts can play in that?
Sure. Very, very good question. A very important question. I think we have jurisdiction, of course, over a variety of state and local ordinances, state laws, and then the regulations and bylaws that are promulgated thereunder. Many of them impact wetlands and coastal resiliency measures, development along the waterfront. And of course, in the land court, we're only applying the Massachusetts state regulations, so we're not in a position to be applying any federal legislation and regulations that might change over time. And so cases come for us to apply those regulations. There are usually parties who are developers of a particular piece of land and need one of those permits, and maybe abutters who have taken appeal of an approval, or it's the developers against the town because they've been denied under those regulations. So our role, is to carefully apply either the state law or the local law that is at issue to the facts of that case and adjudicate accordingly. So it will be an important role in the coming years as Massachusetts continues to tackle those important issues, coastal resiliency, wetlands protection, clean water, clean air. Much more than environmental, we have affordable housing issues in the Commonwealth as well that need to be addressed. So I expect those issues will be coming in front of us.
Thank you. I really appreciate your explaining all of that. And I know that Councilor Kennedy thinks very highly of you, and I do.
Thank you very much.
By the way, I apologize for the, how dark it is in here. Apparently Maura Healy forgot to pay the full bill. Councilor Iannella?
Thank you very much, Mr. Chairman. I don't have any questions. Your Councilor Terry Kennedy, strong supporter of yours. He called me once your name was submitted to the council, and with his recommendation, your background, you can count on my support next week.
Thank you very much.
Councilor Ziegler?
Thank you,
You
Mr.
did about an hour's worth, right?
Yeah, good morning. Thank you, Mr. Chairman. And thank you, Ms. Flores, for putting yourself forward. Congratulations on your nomination. And then also want to thank you for taking time to speak with me and allow me to pose question to you and get to know you a little bit more professionally. So during our conversation, we covered a wide range of topics, from your experience, challenges you see in the court, and just your view of how the court can be, improved in order to expand access. And I wanted to bring that piece of our conversation to the forefront today. And so we talked about language access issues and just overall general access. And so can you speak a little bit to how you intend to elevate these issues and improve them from the bench?
Sure, thank you. That's a great question. I really appreciated our call and you had some really great questions. I think I hesitate always to answer that one because I've never been on the inside of how this court operates. And so I sort of hesitate to, look through a critical lens at the way things are going on without having been there. I'm somebody who does not, if there's an inefficiency that I think that I can fix, I'm going to jump in. I think we talked about looking forward to joining the judicial committees that exist to address maybe inefficiencies in the court and specific rules that could help improve the process. I know the governor's 2024 Affordable Homes Act already made the deregistration process quicker, and additional resources have been also allotted to the title examination side of the land court. So improvements, I think, in the last few years especially have already made things quite efficient, but I'd really look forward to learning the ins and outs and lending my assistance where I can to, continue to help improve those efficiencies.
I definitely appreciate that. One of the main skills that we look for in a strong judge is the ability to listen, right, and to communicate. And as you mentioned earlier, we did get a stack of about 10 or so letters. And one of the threads within those letters was that you were a strong communicator, which is key. And I appreciate that skill that you bring to the table. And that was my only other question. I appreciate you taking the time to answer my questions in our prior conversation and the questions that my colleagues posed to you as well.
Thank you very much.
I'm sorry, the girls want to make sure that their allowance is not going to get cut. Can you?
That's my question, my next question.
Okay.
Exactly.
They asked me to ask that, so.
I was very worried about that. I noticed that they had the cheaper version of the Louis Vuitton bags. So I was worried.
version.
As I said, cheaper.
Oh.
We had a great talk at my office, you're clearly qualified. One of the advantages that you have over all of us in terms of us questioning you is none of us really do much in the land court. I'm probably the only one here who's actually tried one land court case about 35 years ago. I'll never do that again. So, yeah, you know, so we have to rely on what other people tell us about you because we don't have an expertise there. And everything that we heard has been absolutely terrific. And, you know, we respect Judge Roberts and your colleague that came in and testified. That means a lot. I'm looking forward next week to put 2 weeks from now, actually, we're not meeting next week, to putting your name in nomination. And I don't know if in land use practice, you know math, but if you know how to count, I think you're gonna be okay. All right, see you later.
Thank you so much.
And we have another. To hear from Nick, from what I understand, has been doing a great job for the last several years on the Appellate Tax Board. And I, for one, am pleased that the governor renominated you. And Nick, you said you brought one witness?
Yes, sir.
We'll hear from your one witness, please. Thank you for your testimony.
It's my time in the spotlight right here. Hello, my name is William Doherty and I'm Chief Clerk at the Appellate Tax Board. Thank you for allowing me the opportunity to speak today. I've been asked to speak on behalf of Nicholas Bernier and to keep my remarks brief, and so I will. I've been employed at the board in various capacities for nearly 25 years. In that time, I first got to know Nick when he was appearing as a litigator on behalf of his clients in hearings before the board. Nick always represented his clients professionally and effectively. And for the last 2.5 years or so, Nick has been fulfilling his duties as a commissioner at the Appellate Tax Board. As a hearing officer, he is responsible for adjudicating tax appeals. He hears testimony, considers evidence, and then makes a decision with the consent of the board. Nick is a capable member of the board, and he has the ability to hear and decide tax appeals involving disputes with the Department of Revenue, as well as real estate tax appeals originating from the 351 municipalities throughout the Commonwealth. Now, a little bit about the Appellate Tax Board. The board functions and operates as the state's tax court. We receive thousands of tax appeals annually, and we hear hundreds of cases each year. The ETB certainly is not the biggest agency in the Commonwealth, but we are staffed with dedicated employees who are committed to fulfilling the board's core mission. As alluded to previously, the board adjudicates tax appeals and promulgates decisions while following the rule of law. It is my hope that your nomination of Nicholas Bernier to a term as a member of the Appellate Tax Board will lead to the board's continued success. Thank you for your time and consideration.
Thank you very much for coming here. Do you have any questions? Council candidate?
How will Council Ferraro certify the basements coming?
That's being held in abatement.
Being scheduled.
All right, Commissioner, Bernier, do you want to speak? You have anything to say?
Sure. I just want to thank everyone for the time. I basically have spoken to every one of you at one point or another. And I want to thank you all for your constructive comments and concerns. I believe we've done a lot in the past 2 years. We've revamped the rules. We're using Zoom hearings. I think we're giving taxpayers more access around the state. I also think we can do more. And that's my goal. To continue to do that, to continue to improve, and to continue to give everyone access to our services and our decisions. One thing recently I was very proud of, and I think I mentioned it to several of you, Boulay v. Stowe was a case, and it was supposed to be what they call a single member case. So it's kind of a quick thing, but to me, it sparked an issue, and I brought it to members of my board. And we thought the Department of Revenue might have been giving some bad advice to towns. And we looked at the issue, and we believe the advice they were giving towns was incorrect. And it was such a small issue because there's only $223 in taxes, but it was to seniors who qualify. And it's an exemption on your CPA, and it's an elective in the town. And just because they had done some basic estate planning, the assessors were being told to deny these claims. So the only reason why this particular family filed was because their son was trained. I don't know, I forget if he was an accountant or a lawyer. He knew enough to bring this claim forward. So my thought was, well, how many other people in a similar situation statewide don't have that resource, don't have that person really looking out for them? And $223 may not sound like, in the prime of your career, it may not sound like a lot of money, but when you're living on a fixed income, it's a big deal. So instead of just doing a quick single member decision, we did a full findings of fact and published it statewide. And the goal is that'll help other assessors throughout the state, grant these exemptions when they qualify, when taxpayers qualify.
Thank you. It's got to go right around the table, like formalities. Does anyone have any questions or comments or anything? Councilor Iannello.
No questions, just a comment, 2 things. Attorney David Saliba, you know who he is, spoke highly of you. I actually I met with him on a different issue, and I mentioned you were coming. Oh, he's a good guy, he's really fair. So I want you to know that. And your Councilor Joseph Ferreira, strong supporter of yours, and when your name comes before us at the next meeting, you can count on my support.
Thank you. Council Kennedy.
I just want to reiterate that Joe introduced me to, a long time ago. I think long before you were on the tax board. He's obviously a big fan of yours, huge supporter.
Thank you. Thank you. Councilor Paul.
Council Ferreira and I share an affinity in that we don't live in Metro Boston and we care about our regions. And when I first met you, when you were first appointed, it was because Councilor Ferreira genuinely was in your corner and genuinely talking to me about you. So look forward to supporting you again. Thank you.
Thank you. Councilor Ziegler.
Thank you, Mr. Chairman. And thank you so much for taking the time to speak with me, Mr. Bernier. I appreciate our conversation. We talked about, advocacy for seniors. We also talked about taxpayer advocacy as an area that you wanted to focus on. Can you talk a little bit more about that?
So we're a small agency. We do a lot with very little resources. My goal is maybe to procure some more resources in a better budget season, and to work with the cities and towns and really go. I live in a gateway city. Get more access, especially in those gateway cities, to try to explain the process. Just because you don't live in a fancy town doesn't mean you shouldn't be able to abate your taxes and understand why you're paying what you're paying. But again, it's a resource issue.
Thank you. I appreciate that, and I appreciate your dedication to wanting to expand more knowledge, because as you mentioned earlier, not many people may be aware of the board and the work that you do and the resource that you can provide to them to alleviate some financial hardship. So thank you for putting yourself up for the appointment. And that's all.
Thank you, Council.
Any other councilors? Councilor Dolan.
Just briefly, Stowe is in my district. So thank you for your work on Bully versus Stowe. And I appreciate the work that you did on rules that we discussed. Briefly explain what the ProHack rule was. It was changed.
So before we had these rules, you'd have just random people representing taxpayers. You'd have enrolled agents and, New York law firms that didn't have a Massachusetts attorney, and frankly, they would just mess things up. They, bombard us with discovery. They wouldn't bother to read our rules. We don't use the Mass Rules of Procedure. We have our own rules, similar to the Probate and Land Court. So, because of that, we decided as a board that we wanted to make sure that when people are being paid to represent a taxpayer, that they know what they're doing. That was a simple, and that's really kind of a way of protecting taxpayers from less than scruples. And not all of them are acting in bad faith. A lot of them believe they know what they're doing, but they don't bother to read the rules. That's the issue.
Appreciate that. Counselor Farrar worked for a long time. Appreciated hearing what you said.
Thank you very much. Council Civil.
No questions, but I just wanted to congratulate you on your reappointment. And thank you for taking the time out to meet with me to speak about your experience. And I think one thing that stuck out to me is that how you're looking to do more when it comes to communication and outreach, making sure that we have multilingual communications for those who don't speak English, but making sure that they're still connected and understanding the process of when it comes to tax information.
And I have to compliment my clerk, Doherty, who's actually has been working on that. We have a new translation service. As I mentioned, we're not under we're not under the trial court. We don't have access to their services. It's through our own thing.
Thank you.
Anyone else? All right, that concludes your hearing. We look forward to voting on you in 2 weeks. Thank you very much.
So coming in.